Welcome to video 3 of 3 in our video series on removal and remand. In this video, we will discuss phase 3. That is the policing phase. Phase 3 corresponds with the rule of enforcement and the rule of remand. Once the case has been removed to federal court from state court under 46, the court must determine whether the removal was both procedurally proper and jurisdictionally sound. Congress has divided these two inquiries within 1447C. Procedural defects must be raised by the plaintiff through a motion to remand within 30 days of the notice of removal. Jurisdictional defects, like lack of subject matter jurisdiction, can be raised at any time before final judgment. So let's go ahead and look at the language of 28 U.S.C. 1447. 28 U.S.C. 1447A. In any case removed from a state court, the district court may issue all necessary orders and process to bring before it all proper parties, whether served by process issued by the state court or otherwise. What does that mean? Once a case has been removed, the federal court steps into the shoes of the state court, and as such may issue any orders needed to organize, manage, and bring the case before it and all of the proper parties as well. 1447A ensures that the case that has just been removed from state court does not become stagnant, right? It keeps moving. The federal judge now has all full procedural control, even over the parties who have not yet been served. Let's go to B. 28 U.S.C. 1447B. It may require the removing party to file with the clerk copies of all records and proceedings in such state court, or the federal court may cause the same to be brought before it by writ of certiorari issued to such a state court. What does that mean? Here's the plain language. The federal court can require the removing party to file all state court pleadings and orders, or it can issue a writ to have the entire record transferred. So think of this as record collection, right? The federal judge has the authority to get the whole file, not just fragments, but the whole case. We learned that this is generally the responsibility of the removing party anyway under 1446. But just because we have a rule that explains what parties are supposed to do doesn't necessarily mean that it actually gets done. So it's nice to know that 28 U.S.C. 1447 gives the court federal specific authority to get whatever it may need in order that the newly removed case continue to be managed and worked. Let's turn to 28 U.S.C. 1447C. We like procedure, right? So this is going to be, what is the procedure after the removal has taken place? A motion to remand the case on the basis of any defect other than a lack of subject matter jurisdiction must be made within 30 days after the filing of notice of the removal under 1446A. If at any time before the final judgment it appears that the district court lacks subject matter jurisdiction, the case, look at my language, shall be remanded. An order remanding the case may require payment of just costs and actual expenses, including attorney's fees, that's the Atvis case, incurred as a result of the removal. A certified copy of the order of remand shall be mailed by the clerk of the court of the state court. The state court may thereupon proceed with the case. Here is the plain language. Subsection C of 28 U.S.C. 1447 is the heart of 1447. It divides remand into two categories: procedural defects, right, such as late removal or missing consent, right, must be raised within 30 days. Jurisdictional defects, such as no diversity or no federal question, can be raised anytime before judgment. And if jurisdiction is in fact missing as a jurisdictional defect, remand is mandatory. It is not discretionary. The court may, under 1447C, also award attorney's fees and costs if the removal was objectively unreasonable. Finally, a remand becomes effective only when the federal clerk mails a certified copy of the remand order back to the state court. Only then may the state court resume proceedings. Yeah, it's procedural. It's heavy, but this is civil procedure. 28 U.S.C. 1447D. An order remanding a case to state court from which it was removed is not reviewable on appeal or otherwise, except that an order remanding the case to state court from which it was removed pursuant to section 1442 or 1443 of this title shall be reviewable by appeal or otherwise. We like plain language, right? Here's the plain language. Once a case is remanded under 1447C, that order usually cannot be appealed. Congress barred appellate review to prevent delay and endless ping pong between the courts. The only exceptions are if the case was removed under 1442, which is federal officers, or 1443, which is a civil rights case. Those two instances where removal was under 1442 or 1443 may be reviewed. Just those two. Okay, let's keep going. 28 U.S.C. 1447E. If after removal, the plaintiff seeks to join additional defendants whose joinder would destroy subject matter jurisdiction, the court may, this is really simple, right, deny the joinder or permit the joinder and just remand the case to state court. Plain language, after removal, if the plaintiff wants to add a new defendant whose inclusion would destroy the diversity, the court faces a choice. The court can either deny the joinder and keep the case in federal court, or the court can permit the joinder and send the entire case back to state court. This balances fairness to the plaintiff, who may have discovered a proper defendant that they had overlooked, with the defendant's right to a federal form, right? This decision to either deny the joinder or allow the joinder and remand the case back to state court is a discretionary decision that is made by the federal court. So in short, in our phase 3 of policing, that's 28 U.S.C. 1447, we have some procedure after the removal. A, gives the federal court power to manage the case, right? Brings in the state court record, right? Governs motions to remand, deadlines, and fees, limits appeals of remanded orders, and covers post-removal joinder that may destroy jurisdiction. Together, These provisions ensure that once a case is removed, the federal court has both procedural authority and a roadmap for deciding whether it being the case properly belongs in the federal court or not. So let's look at the big picture, the relationship between 28 USC 1441, 1446, this should be 46, and 1447. I think I can fix that right here. And we're going to go back to our current slide. So let's look at the relationship between 28 USC 1441, 1446, and 1447. 1441 talks about the power, right? That's the authority to remove. Defines what cases are removable. 1446, that is our procedure. That's phase 2. That tells us how the removal is executed. 1447, that's phase 3. That's our post-removal review. And it functions so that federal courts review and decide whether to keep or remand the case. Let's practice. That means that we're coming quickly to the end of our removal and remand. So we've got a hypothetical here. Procedural versus jurisdictional defects. Because remember, 1447 divides the defects into 2 categories. We have procedural defects that must be identified by the plaintiff within 30 days, which is the time that they have to file their motion to remand based upon a procedural defect. And then we have our jurisdictional defects that can be raised at any time before the final judgment. Here's our hypothetical. On February 1, Patricia, a citizen of Mississippi, sues Deltaco, a business which is incorporated in Delaware with a principal place of business in Texas. And second defendant, River Gas, which is a citizen of Mississippi. And Patricia, the plaintiff, sues a Mississippi state court. The complaint alleges state law negligence, right? And property damage of $250,000. Deltaco is served on February the 5th. River Gas is served on February the 10th. See, we have a later served defendant. Okay. On March 10th, Deltaco files a notice of removal in the Southern District of Mississippi without River Gas's consent. Uh-oh. River Gas never joins the removal. Uh-oh. The federal judge later learns that both Patricia, the plaintiff, and River Gas are Mississippi citizens. Ooh. So, right? Have you thought about it? Let's keep going. Oh, sorry. Here's my questions. Oh, yeah, I did it this way so that you could continue to look at the fact pattern as I asked the questions. Was the removal proper under 1446? Okay, that's enough time. No. River Gas did not consent. Problem. That violates the rule of unanimity, which is 1446 B2A. That is a procedural defect, not a jurisdictional defect, which means that Patricia would have 30 days, from the time that the case got removed to file a motion to remand. Got it? See, these are easy. Question 2. What does 1447C require? 1447C, what does that require? I kind of just gave you the answer as part of question number one. Patricia must file a motion to remand within 30 days of the notice of removal to preserve that procedural objection. If she waits longer than 30 days, the defect is waived, which means doesn't get removed, and she's stuck in federal court. Question three. What if the court later discovers Patricia and Rivergas share Mississippi citizenship? What if the court later discovers that Patricia and Rivergas share Mississippi citizenship? Well, what is that? That's a jurisdictional defect, right? That's a lack of complete diversity. And under 1447C, the court must remand at any time before final judgment. We don't have a final judgment yet. So that's a mandatory remand. Yeah. Question four. What about 1447E? Do you remember 1447E? What about 1447E? Suppose Patricia dismisses Rivergas after removal. So Rivergas is gone. Then moves to add a new Mississippi distributor 6 months later. What happens? Well, the court has two options. What 1447E? The court can either deny the joinder, right, and retain the jurisdiction, or the court can permit the joinder and remand the case back to state court. Here's the last question. What happens if the judge orders a remand? Once the certified copy of the remand order is mailed to the state court clerk, that's 1447C, very last sentence, the remand becomes effective and the state court regains authority. Is it reviewable? What does 1447E says? The remand order is not reviewable on appeal unless it was removed under 1442 or 1443. So easy, right? 1446 gets us into federal court procedurally. 1447 tests whether or not we belong in federal court or whether or not we get to stay in federal court. A procedural defect can be forgiven if not raised quickly, but a jurisdictional defect is fatal at any time prior to the final judgment. And once the federal clerk mails a certified remand, the federal court's doors are closed. This is so much fun, and we hate to leave it. Let's do one more hypothetical. After the court determines that removal was improper in Patricia versus Deltaco, Patricia moves not only for remand under 1447, but also for just cost and actual expenses, including attorney's fees incurred because of the removal. Deltaco argues it removed in good faith because it believed federal environmental regulations were implicated, even though Patricia's complaint is purely based on state law. Patricia argues the law is settled. There was no colorable federal question, and Deltaco should have known better. Do I have a statutory anchor? Right? She says the law is settled. Do I have a statutory anchor? An order remanding the case may require payment of just costs and actual expenses, including attorney's fees. I've got a statutory anchor. That's 28 U.S.C. 1447C, right? So what do? Well, Patricia has a right to seek the cost, expenses, and attorney's fees, right? Because 1447C gives her the right to seek cost and attorney's fees. But remember that 1447C is discretionary. It does not require the judge to award fees. It says that it may award fees, right? So that is at the discretion of the federal court. If Delta Co. relied on a vague reference to federal environmental standards, but the complaint never cited a federal statute or agency order, do you think that's objectively reasonable? Thoughts? Yeah, I agree. Probably not, right? The law on federal question and removal, right? Atvis and Motley, of all cases, is really pretty clear about the well pled complaint. Yeah. What about this? What if Delta Co. removed the same day a major Fifth Circuit case came out expanding federal preemption under an environmental statute, and they believed the new precedent applied? What do you think? Is that objectively reasonable? Probably, right? Even if the court later disagrees, that looks less questionable than a vague reference, as in question one. What about question three? Why make the standard objectively reasonable rather than automatic? What do you think? Well, one belief is to avoid discouraging legitimate removals, right? Congress wanted to deter tactical or frivolous removals, right? Congress is trying to deter gamesmanship, but Congress really isn't trying to penalize defendants for reasonable mistakes. If it is reasonable, but it was a mistake, well, you're probably going to get the benefit of the doubt. If it was unreasonable, then it's going to start to look like bad faith. So, what are the key takeaways? The fees under 1447 is discretionary. The governing standard about fees is this Martin v. Franklin case, which we did not review, right? If the removal is proper, but you're not probably not going to get fees, right? Because there's nothing that seems to be of bad faith. Now, if you're acting out of gamesmanship, bad faith, then yeah, you're probably going to have some attorney's fees, right? The goal is to punish the abuser, not the objectively reasonable mistaker, right? Okay, here's the wrap up. This is it. Section 1447 ends where removal began. Some basic fairness. The defendant has the privilege to remove, but not the right to waste time or resources. Congress gave the court discretion to balance both of those equities. You don't get penalized for reasonableness, but there are consequences to pay for gamesmanship. That is the beginning and the end, 3 videos later, of the doctrine of removal and remand. Can't wait to get to venue, transfer, and form selection. I'll see you in the next series.